Good evening. Good evening and welcome to my taster on SQE1 land law. It's lovely to see a few familiar faces. Hi, Yulia. Nice to see you. Anastasia. And welcome to some new faces as well. Really lovely to see you guys tonight. So before we start, let me just explain a few housekeeping things before we get going. Firstly, I am, of course, recording this session and it will be posted on my YouTube channel within 24 hours. So you can watch it as many times as you want, all public access, no problem with that whatsoever. So that's number one. Bearing that in mind, as it is being recorded, I totally understand if you want to turn your cameras off. You're more than welcome. If you don't mind, not a problem. I love to see your faces. It helps me with my teaching. It's much better. But if you do want to turn them off because it's public, I totally understand that. So I'll leave that up to you entirely. So moving on from that, what are we going to do this evening? Well, firstly, for those of you that haven't met me formally, my name is Elliot, Dr. Elliot Schatzberger. Do call me Elliot for obvious reasons. I am an SQE provider. I've been doing this for, well, since it began, really. And before that, I was teaching and running a program called the OSCE program, QLTS, which was essentially for overseas lawyers. It was the forerunner of the SQE. And I was doing that about 6 or 7 years before I switched over to SQE and before I started up my own provision just over a year ago, formally. But before that, I was doing it informally. So I've been doing this for a very long time. What do I do? Well, you're here tonight to have a look at how I run my training, my provision, and how I help you get ready for the SQE. I've had quite a lot of students this particular run of SQE exams going through SQE1 exams over the last couple of weeks. The feedback has been really great, and I'll explain that in a moment. But one of the words that is used, and I make no bones about this, and I can't even apologize for it, it's nothing to do with me, it is a brutal set of exams. That's the word that has been used. Brutal. Why is it brutal? Well, first and foremost, SQE 1 is very broad, as I'm sure you know. Many, many, many subjects, all the way through from contract law, land law, to subjects that you don't do on a normal undergrad law degree or a GDL, like, for example, solicitors' accounts, things of that nature. Ethics, professional conduct run all the way through as well. But there are a lot of what I call normal, run of the mill LLB law type subjects, land being one of those. Now, we put out a poll a week or so ago asking you guys whether you wanted to do land or whatever else you might have wanted to do. And land was the one that came up. So I'm going to focus on land law tonight, going through with you 5 key questions from the first chapter of the books I use. And I'm going to explain that in just a moment as well. But before I get into that, how do I teach? Well, I teach in this format. So it's very, very personal. It's very in person, very interactive. My students ask me questions as we go along. I have no problem with that. It's much more than you get from, let's say, other providers who I'm not going to name, who throw material at you and just ask you to read. So this is a much, much more interactive way of doing it. Also, not only that, what my students find and what they tell me, and what I think is undoubtedly true, is that it is really great to have somebody to explain not just the law, but the tips and the strategy of how to answer these questions. There are, as I'm sure you know, 360 questions that you need to answer for SQE1. Oh my gosh, so many, so many. And they work so that you do 90 on morning one, 90 on afternoon one, and then that's repeated on another day. So you get 90 and 90. Now I've done the maths. I know that's sad, but I've done the maths. And what that means is if you work out the timing, you have 1 minute 42 seconds to answer each question. Oh my gosh, that is what makes it brutal. It's fast, it's furious. So technique and strategy is really, really important. And I'm going to show you some of that when we go through our questions this evening on land law. But one thing I wanted to share with you was some of the feedback that I've got from my students over the last week or so. Two things that they picked up on: familiarity and confidence. That's what they said very kindly that I gave them: familiarity and confidence. Let me just break down what that means. Firstly, I use a set of books in my teaching called Revise SQE. You may be familiar with them, you may not. I'm going to show you how I use those books in just a moment when we start going through these questions. Revise SQE. They are by far the best source out there by a very long way. They are accurate. They're in line with the exam questions. They are right on the money. They give you no more, but no less than you need to help you prepare for the exam. One of my students a week ago messaged me in the evening. She'd just come out of FLK1 on the very first day. I think this was 2 weeks ago-ish. And she said to me, "Oh my gosh, thanks to your training, I recognized half these questions. I was so familiar with the format. You were right. Revise SQE are so accurate, so on the money. The format, the length, the type of questions are absolutely what comes up in the SQE exam. So that is great to know. I knew that already, but it's great to hear that from my actual students. Now, for the purposes of full disclosure, I'm affiliated with Revise SQE now. Okay, I work with them. I'm actually authoring one of their new books, okay, which is Wills and Probate for SQE2. That's coming out in April. Very exciting. I'm writing that one myself. I'm also writing a lot of their revision questions for FLK1 and 2. That's coming out later in the year. So I am working with them, okay? However, I'm only working with them because I had enormous belief in their product to begin with, okay? One of my students, literally about 2.5 years ago now, showed me one of their books. I'd never seen them. I was teaching her with my own materials, my own questions, and she showed me one of these books. I've never seen them before. And I was like, oh my gosh, they are amazing. So I started using them and I found they are absolutely brilliant. So I emailed Revise SQE and told them, simple as that. I just said, I made a little video and I put it on TikTok. I've got a TikTok channel. I've got a YouTube channel. Some of you found me through that. And I posted a little video saying how great they are. They responded by getting in touch with me, hence why I now work with them. They offered me a position writing for them. I'm also, by the way, and this is hot off the press, okay? Very few people know about this yet. It is on their website, but they are turning all of their books, hard copy and e-version, they're supplementing them with audiobooks. Oh, how good is that? So you can just put your headphones in and listen as you are in the park, on the tube, on the train, whatever. And guess who's recording those books for the voice? Me. It's very exciting. So that's my new project that is coming on. And I've already recorded the first two, legal system and dispute resolution. They're coming out later this year as well. But I wouldn't work with them. I never work with anyone that I don't believe in, honestly. Okay? I've been at the same law schools, the same universities for 20 years now. Why? I believe in what they do. If I don't, I go. Not that I normally make the wrong choices, but that's why I use Revise SQE. So they are really, really good. So I'll talk about how we're going to use those in a moment. So familiarity was one and confidence was the other. And this particular student, and quite a few of them actually, have got in touch with me saying, oh my God, you gave me so much confidence. And that's not just about the learning of the law. I always assume to a certain extent that you already have a little bit of legal knowledge. And I expect you to learn that legal knowledge or revise that legal knowledge in your own time to a certain extent. There isn't time for me to teach you LLB law, for example. This is all about getting you ready for the exams. So, how do we do that? We focus on the strategy, the technique. That's really what this is all about. Now, of course, I go through the law. You'll see that in just a moment. But those things are really, really important. Okay. When I learnt law, especially land law, it was made very clear to me that it's very important to understand the real basics. And then everything else fits around that. It's a bit like doing a jigsaw puzzle. Okay. I was taught by one of the leading experts on land law in this country, a guy called Professor Martin Dixon. Ring a bell, Zara? Hi, Zara. Okay. Zara was also taught by Martin Dixon. An amazing man, an amazing man. And I worked with Martin for many years. And when I teach at university, I use his textbook. So Martin taught me the value of clarity, of making sure that you understand the basics. Not only that, Martin was very good at using normal, everyday language so people could understand. I've also, I also pride myself on doing that as well. And also, apart from SQE, I've been teaching overseas students now for 20 odd years. So I've got very used to making things clear and easy to understand. Complex pieces of law, I try to make them as simple as possible. So enough about all of that. Moving on to land law, because that's what we're going to focus on tonight. And I want to move on. Obviously, if anyone has any questions, stop me, ask away, type them in the chat box. Not a problem, okay? You can stop me at any time. But let me talk to you a little bit about land law. Now, what I do with my students, because this is a taster class, and when I have my students on Zoom, my delegates, my paralegals that I'm getting ready for SQE, when I begin a new topic, land law, criminal law, solicitors' accounts, whatever it might be, my first session or part of my first session is to just give a little background on that topic. And I'm going to do the same with you tonight. A little bit of background, not much, on land law, just a little bit. So I'm going to start by just showing you what I tell my students week in, week out when we do these new topics. And land is a great example. So if you'll bear with me, let me just give you a little bit of that as I would my students every week. Now, I've been teaching land law this week at one of the universities that I teach at. And it's brand new. They only literally started last week. It's a January start, and they've got their assessments in May. So it's a really quick 12-week module that we do. We do 6-month modules now. It's not really 6 months. It's about 12, 13 weeks. So we do that with them. And I started in exactly the same way. So I asked them a question, and you might be rather familiar with this kind of concept. I said to them, when you study criminal law, and some of you may practice criminal law, paralegal, whatever, if your lecturer says to you, next week, we're going to be doing about murder. You already know what murder is, right? Murder is a dead body on the floor that shouldn't be there, right, Yulia? A dead body on the floor that simply shouldn't be there. That's a murder, generally speaking, maybe a manslaughter. But you kind of know. If we're dealing with Other areas of criminal law, theft. You know what theft means. If I break into Anastasia's house, hi Anastasia, okay, and I steal Anastasia's laptop, all right, it's theft, isn't it? And if I'm not invited into Anastasia's house, not only is it theft, it could be burglary, of course. If I use violence to do it, it's robbery. So all of those things we are relatively familiar with. Let's take another example. Let's say that I'm going to sell you my car. If I'm going to sell you my car, there is offer, there is acceptance. We kind of know what that means. And that gives us contract law or part of it. But land law, oh my gosh, the terminology is difficult. Registered, unregistered, easements, covenants, mortgages, estate contracts, overriding, overreaching. Oh my goodness. How complicated is all of that? So the language, the terminology is difficult with land law. I also make an analogy in my own textbook that I've written on land law, by the way, and that is if you get the foundations wrong with land law, the whole of it falls apart. It's a bit like building a house itself. If you have good foundations, your house stays up. If you don't, it crumbles. Learning land law is similar to that. So why is the language so difficult? Mainly because I'm afraid English land law goes all the way back to William the Conqueror, medieval. So it's not surprising. Now we have got rid of quite a lot of the old words and terms. When I was at law school, we were still using them. Sockage, Frankelmoin. I mean, let's not even go there. Okay? But now it's a little more straightforward, but it's still very rooted in feudal England. Why? William the Conqueror came over from France. He won the Battle of Hastings, if you know your history, defeating Harold, and he took the throne of England. He then took all the land, okay, for the monarchy. Now, Martin Dixon, who I referred to earlier, in his texts and in his lectures, refers to this as the Norman land grab, okay, theft by the new monarch. But it wasn't really theft because he was the king, do what he wants. So essentially, he took all the land. Even in 2026 now, okay, the land in England and Wales technically is still owned by the monarch. We only kind of borrow the land when we purchase it. If we buy the land freehold, that's the best possible type of land we can buy. It seems that we own it forever and ever and ever and ever. But actually, not necessarily. If, for example, you are a little elderly person, 104 years old, you've got no family, they've all died, you've left no will, therefore, if you then die, where's your property going? If there is nobody left, if there is no will, goes to the crown. Or I should say, goes back to the crown. It's still owned by the crown, technically speaking. Now, this hardly ever happens in real life, of course, because we leave it to someone, we've got family, we leave a will, we leave it to the charities, whatever it might be. So it rarely happens. But in theory, it can. And that is the interesting thing. Now, of course, we can also buy property leasehold. But leasehold is also for a fixed term of years. At the end of that term, it doesn't go to the crown, it goes back to the freeholder. So it's all about time. We never really own our land. That has an impact, even on what Martin Dixon calls modern land law. Because that means that because we don't really truly own our land, other people may have rights. The bank, if they give you a mortgage. Your neighbor, if you give them a right to go across your land. This is why third parties have these rights in land. It doesn't happen in many, many, many other jurisdictions, certainly not civil. But in our system, it does. And that is the reason underpinning it. And I think it's a really important thing to understand, because if you understand that concept, you understand why other people have rights over your land. Third parties having rights over your land. Then you start to go, oh, now I get it. I see why these people can have rights. I was having a conversation a few years back with a very good friend of mine who at the time was my head of department at one of the law schools that I teach in, French guy. And I was talking to him about this, and he could not understand this concept. Okay. He said to me, in France, you buy your land, it's your land. Nobody else has a right across your land, which is true in most civil situations, actually. So in English law, it's very much based on this feudalism. It's rooted in feudalism. Many judges who don't like land law have often commented in court in England and Wales, oh, they used to say, this clanking of medieval chains. All right, it's a bit like hearing the ghosts of the past. They hate it. Because why should we think back to this feudal system? But it's still there. So that really is what land law is all about. It's not really about two neighbors per se. It's about what happens with other people. Banks having mortgages, people having leases of your land carved from the freehold, people that have the right to go across your land, easements, people that are connected to you through a covenant, for example. So all of these points are very, very important. What makes it even more confusing is we still, to a certain extent, have this dual system of land conveyancing, registered, unregistered. SQE love it. They love to ask you about not only registered land, but also unregistered land, the old system. Okay. And we need to understand how all of that works as well. They do like these questions. Now, it's very strange to me, whenever I've taught land law, whenever I've learned land law, unregistered land was kind of not on the syllabus. Why? Martin Dixon was a big, big supporter of this. He removed it from the syllabus where I was taught land law many, many years ago. And he used to say the reason for that is that in real life, there was about 5% of all land that is still unregistered, right? Most of it is registered. Anything that moves triggers registration and has done for many years. But there's about 5% left. And of that 5%, half belongs to the Crown anyway. And that's never going to be registered. So Martin used to say to would-be solicitors and barristers, if ever you come across unregistered land in your practice, call me and I'll help you. Don't bother learning it. Sadly, though, for the SQE, I can't say that to you. I can still say call me, obviously, but you have to know. And in the revised SQE book, there is a really good chapter on unregistered land. Not much, but there is. Okay, so what I'm going to do now is move on. And I'm going to start showing you what I do on a weekly basis. So these are the books that I use. They are revised SQE, these ones here, and they are bang up to date 25-26 versions. They've only just come off the press in the middle of last year. So they're brand new versions, all up to date. So those are the books that I use. Now, let me just go to chapter 1. At the beginning of each book, there's a great section on the exam, on technique, on what you need to know, but I'm going to do that as we go along, given the time constraints tonight. What I love about these books is the coherence of the journey, the chapters. They work beautifully right the way through from beginning to end. This one starts with basic principles, and we're going to look at some of those in a moment, just as a taster. But then it starts to go through registered, unregistered, and then things like co-ownership, easements, mortgages, all the way. Criminal law, exactly the same. Okay? Dispute resolution, ADR, pre-action, issue of claim, they're all extremely well organized. Very logical. Don't know about you. I can't learn anything if it isn't logical. Okay? It has to be logical. Otherwise, I really struggle. Okay? Very structured. So what I do with my students is I go from the beginning and I give them an overview, as I've done with you tonight, on land law. And then what I do, my expectation before each class is that my students have read the chapter ahead of the class. Now, we normally end up in our sessions covering 3 or 4 chapters in every hour, hour and a half that we do. So I get them to read 3 or 4 chapters ahead, but no more. And then we go straight to the questions. Sadly, there isn't time, as I've said, in my sessions to go through every single word of the chapter. That's for you to do. And I don't have time to do that. And that would be like teaching you LLB. What I'm focusing on are the questions, but the chapters are really good and the examples are great as well. So I'm going to move straight on and I'm going to show you what I mean. Each chapter has 5 questions. Now, when you are doing SQE, if you are completely new to this, this is exactly what they look like. And this is what I was telling you about the student who said to me, familiarity. And they look exactly like this. They're about the same length, but they're absolutely the same format. So they start with some facts. They give you a short, factual piece of information. Then in bold, exactly as it is here, they give you a question. And then they give you 5 answers. Now, before I even get going, just want to point out 1 or 2 things that the SQE have talked about. I've been to a number of SQE SRA conferences, Kaplan, where they've talked about how they set these questions, how they expect students to answer them. And what's very important is this. The SRA and Kaplan talk about higher order thinking. Now, what that means is that they are not expecting you just to cite the law. They're expecting you to apply the law in the answer to the question. So it's all about application. Some students have said to me, oh, well, it's really unfair, isn't it? Because all 5, A, B, C, D, E, are all correct. How do we pick the best one? Not true. They're not all correct. Now, there may be 2, maybe 3 that are what the SQE SRA call feasible. Feasible. And you've got to find the best answer. But you'll see what I mean as we go along. So technique. Read the facts. Then look quite quickly at your question. And then find your answer. Okay? But there is some other technique in there that I teach my students. And again, I'll explain that as we go along. But let's take this one as an example. Now, remember, this first chapter is all about the principles of land law. Very broad, right? All of these topics are then extrapolated and looked at further in other chapters. But this is only a start point. This one is on ownership of land. What do you actually own? Let's have a look. So what I do is I read the question out with my students, and then we look at the answer. What we do is I will then explain why the right answer is the right answer, but also pick some of the wrong answers and show why those aren't right. So let me show you what I mean. A client who owns a large area of undeveloped land contacts a solicitor as he's discovered reserves of coal on his land. He asks the solicitor to send him a copy of the title deeds, as he's been informed by a friend that he can sell the coal unless there is an agreement with the coal authority confirming they own it. What's the best legal position? Well, what this is asking you is, do you know what's called the extent of ownership? When you own land, what do you actually own? Now, you own the bricks and mortar. You own the walls, the roof, etc. You also obviously own whatever is on your land. If you've got sheds or trees or bushes or whatever, and they are part of your land within your boundary, you own that as well. This is, of course, with freehold. But what about things that are in your land, under your land? Now, you should know basic land law that you own airspace above your land up to a reasonable height. You can't sue airlines for flying over, but you can stop people having branches or wires or drones lower down. So you own up to a reasonable height. But this is not about upwards. This is about downwards. So what's the rule on downwards? Well, downwards, you own to the center of the earth. That's what the Latin maxim says. There is no limit at all. But what you do own is only certain things. Now, let me just pick up a question. Yeah, Rosie, I'm coming to that. I'm coming to that. Absolutely right. Now, Rosie has got the right answer, because anything remotely valuable or on the face of it belonging to others does not belong to you. And coal is one of those. Okay. So coal essentially was privatized in the mid 1990s, all the coal industry. And therefore there are organizations, coal bodies like the coal authorities, who own this stuff. So therefore it's the wrong way round. You can't sell the coal unless there is an agreement. It's automatic that the coal authority own your coal. You may get a license from them for exploration, for extraction, sure, but it does not belong to you. The same as gold, silver, water, oil, anything like that belongs either to the state or to private bodies who already own it through government licenses. Coal Authority is one of those. So therefore, it is the other way around. Rosie is absolutely right. So look at E. First of all, the client cannot extract. Absolutely not. All reserves are owned by the Coal Authority. Absolutely. Who grant licenses for exploration and extraction. Absolutely right. So again, technique. We know, and Rosie picked up on this very quickly, that the answer is no. The client cannot extract. So we've got to look for an answer that says that. Now, A, for the Coal Authority to have any claim, they need to have a legal agreement registered against the deeds. No, they don't. They own it automatically. So it can't be A. B, no requirement. They can do what they like. They can sell, they can dig. No, they can't. C, the client cannot extract the coal. Aha. That bit is right. But then look, they must ask the Coal Authority to do it. Okay. If they do, the coal authority will cover all costs and give them 50%. No, they won't. So why would that be true? No. And then D says again, you can do what you like down to 300 meters. Well, there is no limit on how far down you can go, but not for coal. So again, nice simple question. But if you know your law, you use your technique, you can answer this quite quickly. But another tip I will give you is this. When you are answering your questions, if you know that is the client cannot extract the coal, those are the only ones we need to look for. And there's only two that do that. If you save yourself, and here's a good statistic, 3 seconds on every question by getting rid of ones quickly that aren't right, overall, you save yourself 20 minutes in the whole exam. That is pretty amazing. Pretty amazing. Okay. So Zara asked me, if you get a license for the coal, what would it mean? Well, that would mean it would be whatever your license says. It may well be that there's an agreement that you keep some of the value. It all depends on the license, Zara. And if the title register states it is not reserved or remains silent, it won't say it's not reserved. It's just automatic, Rosie, that effectively the coal authority will own what is in your land. So it's much more straightforward. Okay, so let's move on. The next one is about fixtures and chattels. Now, again, what is the rule here? If you own a property, if you are selling that property, whatever you put in your sale agreement, you can take with you. Whatever, if it's in the sale contract. But what if it isn't? Like Rosie's question, what if it's silent? Well, then the law has to decide whether something is a fixture or a chattel. Now, chattel, another way of looking at it, is a fitting, right? Now, fixtures are things that are, as it would suggest, fixed to the property. And generally speaking, the rule is if you sell and you say nothing, fixtures stay. Fittings you can take with you. But it's a little bit more than that. So let's just have a look at this question. A client has recently purchased a property. Upon moving in, he's realized the previous owners have removed all light fittings and light switches and replaced them with ones of inferior quality. They've also removed a microwave that was integrated into the fitted kitchen and have caused damage removing it. The client has spoke to the previous owner, who's informed them that these items were their personal possessions, chattels in other words, and they were told they could take them. How should they be advised? Well, there are two main tests. One is called the degree of annexation, and the other is the purpose of annexation. So whether something is a fixture will depend on how firmly it's fixed. That's called the degree of annexation. But there is also something about the purpose. If that particular item was there to enhance the land generally, even though it might be freestanding, it could still be a fixture. Think statue in a garden. It might just be sitting there in its own area, on its own weight. It's not concreted, but it's still a fixture. If the purpose was part and parcel of the whole land. Now, with the microwave, it seems, doesn't it, that it was part of the kitchen, integrated. That means the purpose was that it was part of the kitchen. Also, not only that, anytime you move something and there is damage caused, it suggests that the degree of annexation was quite high. But even with no damage, it will be seen as a chattel. But if it was integrated, then it may be the purpose. So the right answer here is A. Whether the items are classed as fixtures or chattels depends on degree and purpose. Two tests from case law. If there is any damage caused when removing, they'll probably be seen as fixtures. Seems to be damage here. If there is no damage, it will simply be seen as a fitting, unless, again, it was part of the main purpose, which this seems to be anyway. So therefore, what's the answer? Likely that the client will only be able to make a claim for the microwave, not the light fittings, not the light switches. They are easy to take and quite commonplace. So it's got to be A. B talks about if the previous owner received advice from their advisor to remove them, nothing the client can do. Well, what if that advice was wrong? That's the whole point. Can't be right if the law says otherwise. This is all based, by the way, on a case called TSB, the bank, versus Botham. Not that you need to know cases, but good to know principles. C says they're all chattels. No, they're not. D says they're all fixtures. No, they're not. So C and D, completely wrong. And E says classed as fixtures or chattels is only about degree. Degree or purpose. So C and D and E, completely wrong. B is ridiculous because it's kind of saying if the lawyer told you can take them, you can take them. Well, no, that's the whole point of the law, isn't it? So it's got to be A. So again, technique and strategy, get rid of the ones that aren't right. It's got to be A. And if you know that it's degree or purpose, and if there's damage, it's likely to be a fixture, A is obvious. Okay? All right, let's move on. Now, this one is again about ownership. And it's about the difference between legal and equitable. Now, I'm not going to go into this in great detail, but this is covered later on, both in land and in equity as well, by the way. So let's just look at the question, and I'll just give you a heads up on the answer. The client has sought advice in respect to legal ownership of the property that she lives in with her husband. She's received a copy of the title deeds, and it is only her husband who has legal ownership, meaning, of course, his name is on the deeds, on the title, sole legal owner. So far, so good, although not for your client. The client tells her solicitor that she was the one who paid the full purchase price at the time and is now concerned she'll have to leave the property should her husband die before her. No way of getting her money back. In other words, does she have any rights in the property? That's what this question is asking you. She is now approaching her 80th birthday and wants to make sure her affairs are in order. What is the best description of her position? Rosie is right again. Absolutely. So we know that there is beneficial, equitable interest as well as legal. Now, before 2007, different story. After 2007 and a case called Stack versus Dowden, okay, Lady Hale, we get a different scenario. The scenario is simply this. If you have contributed to the purchase price at the time of the purchase, and there is no evidence of any other contribution through time, you have what is known as a resulting trust interest. Okay? Now, resulting trust interest is quite rare in a relationship scenario. Now, on these facts, We only know that she contributed to the purchase price. It does not say she made other contributions over time. Now, the law says after Stack and Dowden that if you are in a relationship and you contributed to purchase and you contribute, as Lady Hale said, holistically through the relationship, refurbishments, looking after the kids, anything, then it would be a constructive trust based on contribution. But if you've only contributed to purchase price, then resulting. And what you get back is what you put in. Just because someone's name is on the title does not mean that they have any real value in the land, even if they technically own it. You can own 100% by way of you paying 100% of the purchase price, according to Lady Hale in Stack and Dowden. Yeah, again, Rosie, absolutely right. It is a resulting trust because of the contribution to the purchase price. If the facts had said she contributed to the purchase price and over the years she did X and Y and Z and A and B, then, Rosie, it would be a constructive trust, according to Lady Hale. Okay? But that is not what's happening here. Okay? Yeah. Rosie, my pleasure. That is a key point, isn't it? The difference between resulting and constructive. And all you've really got to know is that if you contribute to purchase price only, then resulting trust. And you get back not 100%, but the same percentage that you put in. So she's paid 100% of the purchase price. The answer is it's a resulting trust held by hubby for her, and she will get back 100%. There is only one answer here. So C is right. Now, let me just make sure I've covered all your questions. I think I have. You're welcome, Rosie. My pleasure. That's what tonight's all about. But look at A. The client is not shown as legal owner, so no ownership. Wrong. Beneficial. Equitable. Again, Zara will know as well as I do, Martin Dixon used to call this your real value. Your name can be on the title and you own zero. If your partner contributed 100% to the purchase price and through your relationship, you have contributed nothing, even if your name is on the title, but only in that situation. So A is wrong. Regardless of whether the client is shown on the deeds, B, she can clearly show she's got legal ownership because she's paid for the purchase of the property. Wrong. Not legal. Paying for a property does not mean you are legal owner. It means you are beneficial owner. Being legal owner means you are registered with the title in your name at the land registry. So B is wrong. D is absolutely right, other than it says she's married, and it's not 50% anyway. But it does say she's contributed to the purchase price. So that bit is a yes. But then it's no. Okay? The first sentence is right. And I call this the yes, no, no approach. Yes, first bit of the sentence is right. After that, it talks about marriage. Marriage has got nothing to do with it. Nothing. Okay? Now, if they divorced, then that might be different. Then the start point is 50-50. But if you look at the facts, it doesn't say they've divorced. It's her wondering about what her entitlement is. It's nothing to do with divorce or marriage. So D is not right. And E, absolutely right, other than it says constructive trust. This is not a constructive trust. Okay? Well spotted, Rosie. Let's move on. Mortgages. Now, again, mortgages has its own chapter. But let's just quickly look at this as an example. A building society has sought legal advice on their interests in 84 Lower Mast Farm. Now, I was dealing with a student from a part of the world that has no idea what a building society even is. So he made me think for a moment that I should explain that a building society in England plays the same role as a bank. They are one and the same, really. Nationwide in England is a building society. Santander used to be a building society. It is now a bank. It used to be the Abbey National, and now it's Santander Bank. It was Abbey National Building Society. But this student of mine had no idea what a building society was. So from now on, thanks to him, I'm always going to explain it means the same thing. They can grant mortgages. So a mortgage was granted 5 years ago. The legal owners have defaulted and the building society want to seek possession. Now, if it's a proper legal mortgage, they have every right to take possession, okay, under statute and under common law. But let's look. They've obtained a copy of the title deeds, which do not show their legal interest. So they've taken this mortgage, they haven't protected it. It's not on the register as a legal mortgage, but it's still a mortgage. All the paperwork was done. So if it's not on the register, it's not a legal mortgage. It is an equitable mortgage. It doesn't mean they have no rights. But what it does mean is that they've got to go and enter it on the register. Then it will be a fully legal mortgage. There's a lot to this that I could talk about this for an hour, but sadly we don't have the time. But let me just pick up on again another question. Yeah, basically Rosie is right. If it's an equitable mortgage, it is no way as binding or powerful as a legal mortgage. It means effectively you are a bit like, not quite Rosie, but a bit like an unsecured creditor. It's an equitable one only. So therefore, again, look at the answers. B is the only one that it can be. For a mortgage to be a valid legal interest, there's got to be a valid deed executed and registered. If it's not, it will be equitable only. But they can still make it legal by then entering it on the register as a notice. Yeah, Rosie, it does. This is one of those questions where there is quite a lot, as you say, to unpack. But again, basic principles. For a mortgage to be legal, and again, if you know your statute, this is section 1(2)(c) of the Law of Property Act. It's got to be for a fixed time. It's got to be by deed, and finally entered on the register. That's what makes it a legal mortgage. Otherwise, it will be equitable and not as easily protected. But the bank, the building society, can still register it even after the event. Yeah, it's a hard question, Rosie, that one. I agree with you. I agree. But remember, this one is slightly out of context. There's a whole chapter on mortgages. So this is tricky in its own right, to be fair. So let's do our final one for tonight. And this is very similar too. A client has sought advice on the validity of an agreement made with a neighbour over the purchase of a small strip of land. So we are agreeing with our neighbour about buying a small piece of neighbouring land. But it's a verbal agreement. The neighbour told the client the land would be left in the will. The neighbour recently died. Client's been told, no will. Entire estate, including the strip of land, inherited by the neighbour's family. They're now refusing to uphold the verbal agreement. Does the client have any demonstrable interest in the neighboring land? No, absolutely not. Now, okay, Rosie, verbal in this scenario doesn't mean equitable at all. And this is the rule with most of land law, even a mortgage. If it's verbal, which it wouldn't be, it's not equitable. Verbal, Rosie, means that it isn't valid at all. Because any time you are dealing with land, apart from one or two exceptions, like estoppel, every single transaction must be done in writing. Section 52, 53, 54 of the LPA. It cannot be verbal. A verbal agreement for land, and especially, by the way, to sell land in the future, like this one, that would be called an estate contract, is not verbal, is not legal or equitable, but it's certainly not legal. So have a look at C. The neighbor has verbally promised this land to the client. No legal estate, unless by deed and registered, same as with a mortgage. So for a legal sale of land, again, legal, it must be by deed and then signed and then registered. It will then be transferred properly. If it's not happened and it's not in writing, if it was in writing, Rosie, it would be equitable. But verbal, nothing. There are one or two exceptions, as I say, like the doctrine of estoppel. But verbal in land terms generally means nothing. It's not like me, Rosie, trying to sell you my car. We can do that verbally. But for land, land is known as a speciality contract, meaning, general rule, it's got to be done at least in writing, and for legal, by deed. Now, do remember, one more thing I want to share with you. All contracts are not necessarily in writing, but if it's for land, must be. Now, all deeds are contracts, but not all contracts are deeds. Okay? A deed actually says it's a deed. It will be witnessed, it will be executed, it will be signed. Contracts, not necessarily. So remember the difference between a deed and a contract. In land law terms, if it's created by deed, generally it's a legal interest. If it's only created by contract and not by deed, it may be equitable. If it is verbal, it won't be either. And therefore, for land, it will mean nothing. Okay? Rosie, you're very, very welcome. Rosie's saying, I thought if it wasn't done by deed, it would be equitable. That's true, but only if it's in writing. Section 2, Rosie, of the LPMPA 1989, Law of Property Miscellaneous Provisions Act. It's got to be in writing. Verbal means nothing. Okay? So I hope, first and foremost, that you really enjoyed that. But what that showed you is that even relatively straightforward questions have a lot to unpack. They do. And imagine doing those in 1 minute, 46 seconds. It's quick. So there is no substitute for knowing your principles, knowing your basic law. Then you can find the answer. Okay? Wonderful. So let me just ask, are there any questions flowing from any of that tonight? Anyone got any questions? Obviously, if you're interested, whether you want to come with me or you don't, or you have any other questions, just message me and come along. Rosie, thank you. That's very kind. That's very kind. It is my teaching is about pitch and pace. I do concede that is true. Marvelous. So if you do want to get in touch, If you're not already, then drop me a message and come and join me. I've only just, not that this is about selling my course, but I've only just started with my new intake. Okay. Rosie, have a look on my website, or I'll message you, okay? For SQ1 and 2. Have a look on my website, or just drop me a message on LinkedIn and I'll send it to you. No problem at all. Okay. But essentially, I've only just started. I've got 2 groups at the moment. One is working towards sitting in July, and we meet twice a week. The other group is sitting in January, and we meet once a week. Cost is the same, by the way, for both. It's just that with the 6-month, we go twice as quickly. All right. Wonderful. Thank you all so much. And I hope you enjoyed that. Watch out for future tasters. There'll be some more. But again, really great to see you. Thank you for coming. And this will be posted up on YouTube for you. Okay. All right. Thanks all. Thanks all. Have a good night.
Thank you. Thank you.
You're very, very welcome. Bye for now. Bye bye. Bye bye.